You out there in the audience in Zoom land. It's nice to have you here. It's my honor to introduce our first guest speaker of this spring semester, Mr. Keith Wattley, who is based in the San Francisco Bay Area, specifically in Oakland. He is the founder and executive director of an organization that has a strikingly significant name. It's called Uncommon Law. It is a unique public interest organization that works primarily on parole issues, both what goes on within the parole system, and then and advocating for people, individuals, advocating on policy issues, and then providing assistance to people after they get paroled. So it's a holistic program that has been widely recognized. Keith was named one of the inaugural Obama Foundation Fellows, also was honored by the James Irvine Foundation, which is based near us. He is spent a lot of life in the Bay Area. He went to Santa Clara Law School. And then before starting this organization, he worked at another significant public interest organization, the Prison Law Office. But this project has been his work for close to 15 years now, and we're very honored to have him. And with that, I'm going to give the floor to Keith.
All right, so I'm sitting in a small room, not this room I'm in right now, but this room had just a table and two chairs, and the door is locked, and I'm there with my client, Ronnie, and we've just walked out of his parole hearing and crossed the hall and went into this room. Now, Ronnie's a tall, 50-year-old Black man who has a way of sitting like really, really straight, really upright, like even accentuating just how tall he is. He's not full of himself, but always appearing like dignified. So he's dressed in his prison uniform of blue pants and long sleeve blue shirt, and they're both very neatly pressed. We had just sat down, and Ronnie looked over at me, maintaining his composure, and he said, "You know, I just really want to thank you for what you did for me." And I thought to myself, this doesn't really make that much sense, because, see, Ronnie had just been denied parole. And he would now, because of the way the process works, he'd now have to wait 3 more years before he'd get another hearing. And mind you, he'd already been in prison for more than 30 years at this point.
Wow.
He killed a man during a bad drug deal back when he was 19 years old. So in light of the fact he was just denied parole, I was confused that he was thanking me. So let's rewind a bit. We'll go back about a year earlier, and this will start to make some sense. I had just met Ronnie about a year earlier, and before meeting him, I'd read a lot of notes in his file that were saying things like that he didn't have a very deep understanding or explanation for why he'd committed his crime, for example. So I sent a psychologist to go interview him. And after the interview, she told me that Ronnie had suffered pretty extensive physical, sexual abuse as a kid. He'd had several serious head injuries, some of which had been intentionally inflicted by his own family members. And that the nature of these injuries made it very difficult for him to engage in abstract thinking, which is exactly what the Parole Board had been looking for. So I went back to see Ronnie, and I asked him, how well do you understand the things we've been talking about to get ready for your hearing? And he's sitting in his customary kind of straight up, dignified way, and he looks over, and in a voice full of shame and regret, he says, "I really don't understand any of it." Wow. And in that next year that we were working together, I learned several really significant things about Ronnie. I learned that he had been unable to read and write until he was 40 years old. He had learned to really fake and mask it. And when he was in school, teachers passed him along because he was a really good athlete. And even in prison, he was able to just sort of follow along with what other people were doing and never let on that he couldn't read or write. He had, while in prison, he'd been unable to pass some of the written tests for like vocational training and those kind of things. So he paid someone to do them for him. As a result, on paper, he looked like someone who should be able to meet the standards the parole board had set for him. You should be able to answer these questions. And so by the time we got to that parole hearing, we had worked together through his traumatic history. We had identified several programs that could directly help him address his shame, his anger, his drug addiction. And he had really embraced the work and dramatically changed his life. So when the parole board denied him in this hearing, they just thought his progress was too recent. He still had some work to do. So we were not pleased with that result for sure. But when Ronnie was thanking me after having been denied parole, he explained, he said, but before I started working with you and before you sent that psychologist to see me, I thought I was just dumb. I thought I was just stupid. And now I realize there's actually a reason I have the trouble that I have. And I know that I can get help and I can get better. And so in that moment, I realized I'd really helped him to take control of his own life and really start to write the next chapter for himself. And, I describe this case because it shows the importance of looking beyond the label that said that Ronnie was, a violent criminal, a drug addict, a murderer, sentenced to life in prison. Right now, by the way, California holds more than 35,000 people serving life sentences, 35,000. And these are people who are only released from prison if the parole board determines it's safe to release them. And so they've served 10, 15, 25 years or longer in prison before they see the parole board and they decide whether they're safe to be released. By contrast, most people sentenced to prison are serving fixed sentences. So they'll automatically be released after serving that certain number of years without ever seeing a parole board. The people who are released for those fixed sentences tend to go back, 60% of the time. But those who are released from life sentences, usually following convictions of murder, their recidivism rates are around 1%. And it's been that way for many years. So they don't go back to prison once they get out. And the problem is it's very difficult for them to get out. So I want to thank you, Professor Weinstein, for inviting me to meet with you all to share a little bit of my journey. I want to talk a little bit more, come back to Ronnie in a minute, but I also want to tell you kind of how I got there to that place. I was already working as an attorney on a class action lawsuit that was involving people in prison suffering from mental illness and not receiving adequate treatment for it. No surprise there, I guess. And I remember at one point while doing that work, I met a man who he was serving a life sentence. We weren't there to talk about his sentence. We were talking about mental health care, but I'd learned that he was serving a life sentence. And he had already been in prison for 25 years at that point. And I was the first visitor he'd ever had. 25 years in, the first visitor. No family, no one from the outside ever come to see him. So he's like, so this is the visiting room, huh? This is what this is. I said, yeah, this is where it happens. And at the time, my job really was focused on making sure people who need mental health services were actually getting them. And in that work, while I was, I knew I was improving conditions inside prisons in the long term, but there wasn't a strong enough connection between what I was doing and any discernible significant change in the individual lives of my clients. In fact, I usually didn't even know why they were in prison, didn't know anything about their backgrounds, et cetera. What brought me to people serving life sentences was a letter from someone who was serving a 7 to life sentence for kidnapping. And he'd been granted parole, found suitable for parole is the language they use, after about I think about 12 or 14 years. But before he was released, the parole board sent him a letter saying, hey, we're thinking about taking away that parole grant we just gave you. And he wrote and said, I need help. I don't understand how they're able to do this. And I looked at it. I said, well, he must have gotten a new rule violation. Something must have happened to derail his release. And it turns out nothing had happened. It was just they had a policy and practice in place at the time where they would just take a look at and reverse their own decisions sometimes, fairly arbitrarily. And I represented him in this hearing, which is called a rescission hearing, to rescind his date. He kept his date and went home, and I got to see him get a job. I went to his college graduation,
Wow.
met his kid when his kid was born, all that stuff. And I said, okay, I was hooked. I was like, okay, this is fulfilling work. And it felt more like, this is how I want to win as a lawyer. This is how I want to live and work as a lawyer. And so as I worked with his case, and coming back to Ronnie's case, as I was working with these cases, I really realized just how consistently the role of trauma surfaced as a major contributing factor in the lives of people I met in prison. Yet no one was talking about it. I learned that up to 70 or 80% of men in prison and more than 90% of women are survivors of physical, emotional, or sexual violence. And the numbers are highest among Black and brown and transgender people. In most cases, that trauma occurred during childhood, adolescence, and then people spent years or decades building up their armor as protection against being hurt again. And then they live with that armor on for decades after that. And I also learned the kinds of questions the parole board asks really required people to revisit their most painful and formative experiences to understand why they did whatever they did to come to prison. Yet there are very few spaces inside our prisons where people feel safe enough to let down their guard, to be vulnerable, to even explore those issues. So at Uncommon Law, we fill that gap through our trauma-informed approach to legal representation. I want to come back again. The sort of the postscript to Ronnie's case was after that hearing at which he was denied, he got transferred to another prison, to San Quentin, which many people have heard positive things about, mostly because he found what was more of a therapeutic community that supported him, not provided by the prison, but provided by other people who were serving time in prison, by the way. And he thrived there, and he was actually granted parole about 3 years ago. He's out, he's doing well with his wife, and he's got a good job. And this was a life that he just didn't believe was possible for him. But he was willing to be vulnerable, to trust that he could lower that guard in a safe place that would really help take care of him and support him. So that's kind of how that case plays out. The other thing I wanted to say a little bit about is the way in which we use labels to kind of to limit what's possible. I mean, a lot of the labels we talk about now, fortunately, there's an important conversation about shifting the way we refer to people who are incarcerated. We start by referring to them as people, for one, rather than convict, inmate, even defendant, or other terms like that. Because the labels that we use not only define people or identify people, but they also limit what's possible for those people. When we say a person in prison, for example, they're still a person first, with all the potential and all the possibilities that come with personhood. They could be a lawyer, a doctor, a painter, a business owner, a clerk, a waiter, or whatever. But a prisoner or an inmate can only be locked up somewhere. That's it. At least that's what our minds tell us about people that are labeled in that way. Labels also tell us, how to relate to whoever's being labeled. They tell us who to like or dislike, who to care about, who to disregard completely. And I think within the criminal legal field, we use, a bunch of rituals that both attach those labels to they really dehumanize people. They de-individualize people, right? With each step from juvenile to delinquent to defendant to convict to prisoner to inmate, they become less and less an individual, multidimensional human being in favor of being reduced to that one negative thing we've decided they are. For example, Ronnie from that earlier story, he stopped being that toddler, that child, that adolescent whose family abused him, and when he stopped being that, he stopped being someone we saw as worthy of sympathy, worthy of healing. Instead, he became a murderer we should fear, and that's how the parole board related to him. And what's more is that Ronnie had built up so much armor to protect himself that there was no way to see who he really was underneath. So a lot of our work at Uncommon Law is it's focused on peeling off those labels, removing some of the layers of protective armor to see who's really inside, to let them know that they're okay, that they are enough, that they belong to the community, and that they can safely be released. The last thing I'll say about labels is I think about the ways in which white supremacy prevents us, really prevents members of the dominant caste here in the U.S. from being subjected to the same negative labels and treatment as others. We're so used to being told whom to fear, whom to celebrate, that we fail to see the real threats to our democracy and our very safety. I mean, the violence we saw at the Capitol last week, in many ways, it's the same violence we've experienced in Black and brown communities for a very long time. And frankly, that violence is committed by the same people, including people who themselves are sworn police officers. I consider there's this quote in The Nation that I came across where a woman in the crowd was upset as she saw, I think she witnessed when one rioter had been shot by the Capitol Police. Not a whole lot of gunshots fired that day, but she saw this one and she exclaimed, this is not America. She said, they're shooting at us. They're supposed to shoot Black Lives Matter, but they're shooting the patriots, is what she said. So you have the labels of Black Lives Matter protester, you have the label of patriot. And when white people can physically attack not just the Capitol, but the police trying to defend it, threatening the lives of those inside, and then waltz back out to jump on a plane or in their trucks and head back home, rather than being shot and killed on sight. I mean, it shows just how big a role labels, in this case, Black Lives Matter and patriots, play in deciding who we should fear and who we should embrace. So I urge that we all be willing to look past the labels and actually see the people involved. Now, since I've been doing this work, we've been able to see the parole grant rate in California increase from what used to be around 1%. About 1% of people going to the parole board were being granted parole. Now it's up to almost 20%. Now that's an increase, but it's not close to what it needs to be. We have a governing statute that says parole shall normally be granted the very first time these folks become eligible. So even 20% is not close to normally granting. We are really fortunate and proud of the fact that we've now seen 258 of our life sentence clients released from their life sentences. And many of them are contributing in major ways to their communities and their families. We're very, very proud of that. And as I mentioned before, their recidivism rates are 1%. But we also are really clear that the recidivism rate doesn't tell you that much about anybody's life. Because most of us are, as we sit here and talk, we're doing a lot more than just not going to prison. There's a much, much greater richness to our lives than that. And so when you look to see how people are actually plugged into their communities, how they are using the newfound sort of emotional intelligence and communication skills to help others in the community, that's where you can see the impact that people who were formerly serving life sentences can have when they do get a chance to come back to the community. We have a long way to go. There are still way too many people subject to this arbitrary discretionary parole process. One other thing I'll just say briefly, and then I'll see what kind of questions folks have, is a big reason I wanted to speak with you today is because when I was in law school, I had never heard of anyone who practiced prison law until I came to an event like this, actually in my first year of law school. It was a lunchtime sort of speaker series, and an attorney from the prison law office came to our school, and he was joined by one of his former clients. After hearing them speak, I pursued internships, first in an organization being run by the former client, and then in the attorney's office. And I've pretty much been hooked ever since. And a really important part of that story is that the main reason I went to that particular talk was because they had pizza. It wasn't because I was that interested in prisons, frankly. I had some mild interest, concern about prisons. Get this, I even had a sister who was in prison at the time. But it didn't occur to me that I could be an attorney working with people in prison. I mean, there's a lot more to that story that became, better understood by me after I started doing the work. But at the time, it was the pizza that got me, and it was the people that kept me, because I really stuck with it since then. So I'm really, even though we couldn't really feed students today, I'm glad that people were willing to come check us out anyway. We do have internship opportunities at our office.
Oh, good. I was going to ask about that.
We do, yeah. If people visit our website, uncommonlaw.org, you'll see some opportunities we're looking for folks for the summer of 2021 right now. We take students during the school year too. We generally have one or two. And so that's all I want to say, my initial comments. If people have questions or any particular direction you'd like me to go in, I'm happy to share some.
First, I was going to just say, picking up normally, pre-COVID, we normally had pizza or burritos.
There you go.
Unfortunately, I'm unable to serve pizza or burritos or bagels
right.
through Zoom. Since you're already talking about internships, did you have students working on internships via Zoom last summer during the COVID period?
Yes, we did last summer, in the fall, this spring. Yeah, we have students. We have both law students and undergrads work in our office.
Okay, well that's good to know.
Yeah.
I want to just start with a question, and then we'll clearly get questions from the audience. But I think it would be useful for the audience if you would just talk a little bit more, just sort of about the basics of the parole system and how the Parole Board operates in California, because you're clearly having a lot of interaction with them, and those are like the decision makers that must have a major effect on your clients' lives.
Yeah, that's for sure. The parole commissioners are appointed by the governor, and they're generally appointed to 3-year terms. Most of them have, this has historically been true, still true, most of them have backgrounds in law enforcement. Either they have been police chiefs or sheriffs or prison wardens or other prison workers or prosecutors. There are a few exceptions, but most of them fall into those categories. And what I often am talking to my clients about is the fact that these are folks who spent their whole careers locking you up. And the only way you go home is if they feel comfortable with you living in the neighborhood, if not next door. Now, that's not a standard that's written down anywhere, but in reality, that's how it plays out. And some commissioners have told me off the record, that's kind of their standard. They have to have a gut feeling that this person would be safe to release. And there are about 15 regulatory factors of parole suitability that they're supposed to be considering in these hearings. to take a step back, I mentioned that the governing statute says parole shall normally be granted. That's in the Penal Code, section 3041. And it says shall normally be granted the first time someone becomes eligible. So at 7 years or 15 years or 25 years. In practice, most people have to go to several hearings before they get a parole grant. The Parole Board, as I said, is guided in those hearings by these regulatory factors, which focus on the nature of the crime, for sure, but also other factors such as behavior in prison, rule violations, and positive behavior, the kinds of programs someone has participated in since they've been there. And the thing that is most challenging is that right now the Parole Board is able to consider, there's this category they call the past and present mental state regarding the crime. And if you think of that as like, they've interpreted it as full license to consider someone's insight. And when they say insight, they're really referring to this umbrella term under which you can include remorse for the crime, admission of guilt, understanding all the details of the crime, and probably most challenging is being able to understand and articulate all the factors that contributed to the crime happening. And obviously these are subjective factors. And so you have people who just don't represent themselves very well. Even people who've done the work and understand themselves well, they don't always speak very well about themselves. And those people are at a disadvantage. That's if they're able to do the work to connect the dots in their sort of historical, trauma issues and those kind of things. But if they can't even connect those dots, then the gap is the fact that there are very few available programs in prison for people to be able to answer those difficult questions about themselves. So the Parole Board considers whether they can answer those questions, whether they've stayed disciplinary free long enough, whether they can safely be released. In the hearing, in addition to the parole commissioners, each person appearing for parole is represented by an attorney if they want one. There's not a constitutional right to counsel, but there's a statutory right in California. By the way, most of the things I'm describing about California are unique to California. That there's not a federal constitutional right to parole unless a state creates it. And California has created it and provided some protections against its deprivation. So these things I'm describing are what the due process protections are that don't exist in many other places. And so in addition to counsel, they also have the right to see all the documents that are being considered by the board and be used against them. A representative from the district attorney's office is invited to participate in the hearing. They often focus in their comments on the crime itself, saying, oh, the person's minimizing the seriousness of this crime, or they haven't fully admitted to everything they did, et cetera. And survivors of the victim are allowed to participate in the hearings. And they are allowed to talk about the impact the crime had on them, their families, the community, and to talk about here's why this person is suitable or not suitable to be released. That's who's in the hearing. There are a couple of correctional officers who are there just sort of for safety reasons, but the hearings typically nowadays, they take between 2 and 3 hours on average, sometimes a little longer. I've had them go much, much longer. And they announce the decision the same day. So by the time we leave the hearing, we know whether the client has been granted or not. And after that hearing, there's a 120-day review period for the Parole Board to finalize its decision. And in murder cases, the governor gets to review that decision and can reverse it, can say, I don't think this person is suitable for release. I'm taking away the parole date. And the person goes back into the hearing cycle to be considered again 18 months later or so. In non-murder cases, the governor cannot take away the date, but he can ask the Parole Board to reconsider its decision, and often they do. So that's those are the basics. I'm sure I left out some stuff, but let me know if there's
No, no,
something
no.
else.
That's very helpful. One of the things, going back to the first client you talked about, Ronnie, and putting Ronnie, as you described him, in the context of this quote insight,
Yeah.
sort of sounds like Ronnie and a number of the other people are, given the things that have happened to them in the rest of their lives, they are probably the least equipped to be able to deal with this process.
Absolutely right. And these are the folks who spend a lot more time in prison. And so in his case, our work, in addition to supporting him in understanding these things in his own history and how they manifest themselves, but it's also in helping the board understand who he is, helping them understand his story and why he shows up the way he does. Even then, it took a while. It took a couple of years before they fully understood and accepted, okay, yeah, this is somebody who's changed and is safe to be released. But it's a process to help sort of each party understand the other and what the process really should be about.
So you also said, and I read this, that most of the people who are parole commissioners on the parole board are people who have a law enforcement background. I gather that is not mandated by statute. Given what you're saying that the job involves, it would seem like a psychologist or a sociologist or somebody else who had a, let's just say, a background of work in human behavior would be particularly suited for this job. It sounds, for lack of a better word, doesn't sound very diverse or necessarily related to the task.
Right. Well, there's language that that states a preference for a much broader range of backgrounds, including sort of people with some experience in human behavior. But there's no mandate. There's no requirement. It's really up to the governor. And the governor, at least one of the governor's recent appointees was someone who was a social worker. However, this person was a social worker for the Department of Corrections, which is a very different social worker. And so I want to say the governor probably thought he was checking that box, but not really. And so I think we've seen that happen a few times, but it's something that could easily be done in that way. There have long been demands for really someone who's formerly incarcerated to be included on the board.
One member of the audience just sent that question in through the chat function.
Yeah, it would be great if we could make that happen. There may be some sort of rules that make that harder. Someone who's been convicted of a violent felony or a crime of moral turpitude, there may be some restrictions on whether they could be appointed by the governor. But that means it's time to change those restrictions, right? Whether that takes legislation or something else, it's time to change those policies so that the parole board better reflects the people who are appearing before them, because they, as it is now, they cannot relate to them, even if they wanted to. And some probably don't want to, but even if they wanted to, there's just such a gap in their own, personal experiences and background that it's difficult or impossible for them to communicate and understand each other.
As you were saying, there's 35,000 people in California who are serving life sentences. And as we also know, there's a great body of literature now about the massive amount of incarceration in this country that's escalated in the last 25, 30 years. In terms of the people that are put on the parole board and also some of the gubernatorial decisions, how much of this is affected by fears of being, accused of being soft on crime in another election?
Yeah, well, it's a great question. Historically, that's certainly what has driven a lot of the parole decisions in California. When I first started working on cases of people serving life sentences, Gray Davis was the governor, and he made it very clear that if people had committed murder in particular, or were otherwise serving life sentences, that they wouldn't get out of prison except in a pine box. Mm-hmm. And even said things like, I'm going to appoint commissioners who feel the same way. And in practice, I mentioned before, that at the time the parole grant rate was around 1%. That was true, except that was the rate at the parole hearing itself. The governor, Gray Davis, reversed 99% of those. And because, in keeping with his vow, he said, I'm not going to let these folks out. There was a challenge to that, claiming that the governor had an unlawful no parole policy. That challenge was unsuccessful in the Supreme Court, Cal Supreme Court. But it was clear he had decided, I'm not going to be on the wrong side of this issue, the wrong side in his perspective at the time, and have anyone be able to say I'm soft on crime. Unfortunately, I think governors we've seen since then have been willing to take a similar approach. They've been more willing to allow parole grants to proceed than Gray Davis was. That's not really saying much. Even Governor Brown, when he was back in office, reversed too many parole grants. And Governor Newsom still reverses too many parole grants. And the ones that are reversed typically are the cases that either high profile cases or the victim in the crime was related to law enforcement in some way, or a couple other categories of crimes typically get special attention. I think because of the concern for the political cost of a governor allowing someone to be released, even though, I told you what the recidivism rates are. That's been consistent for a long time. And those numbers are not even in dispute. It's just that they don't want to upset certain, groups within their constituency. And so they take this unreasonable position against parole.
So how long you stay in prison may be affected by not necessarily how long you've been there or the nature of your crime, but who you killed.
That's for sure. That's for sure. The other part of this is, I've talked about the way we help people connect the dots in their own trauma histories and be able to articulate that for the Parole Board. That's what the Parole Board is used to hearing and seeing in order to feel more comfortable granting someone parole. But it's a huge mistake to think that process, that development, is what's required in order for someone to safely be released, because it's not. It's just what this process requires. It's an important thing to sort of untangle and not be confused about. Most people, if you sent them to prison for 15 years and did nothing else and you released them, their recidivism rates would similarly be, single digits, because they'd be older, the associations are different, they think differently, their interests, motivations are all different. All that stuff just changes. People age out of the crime. There's all kind of stuff. That's pretty well understood. But time alone isn't a comfortable factor for the Parole Board to hang its hat on. They need to feel like they've done something. They've used their own background expertise in connecting the dots and questioning someone really intensely and producing an outcome that they feel comfortable with. It's like they've had some control over, some say over.
So when you were first talking about Ronnie, you talked about getting a psychologist to see him. And so one question is what is your ability to get, for yourself to go in to see, your colleagues to go in and see inmates, and also people in prison, and also what is the access of psychologists who are, outside psychologists as opposed to somebody who works for corrections? What's the process of them getting to see someone?
Well, there are rules that require the Department of Corrections to allow outside therapists to come in and see their patients or their clients, in our case, inside prison. It's just that almost no one in prison has the resources to be able to afford that. Right. And so we have at times hired psychologists to work with individual clients. In the past, it was more for the purposes of an evaluation and assessment to identify what their needs were, and to also sort of predict their risk, to help the Parole Board understand what their actual risk was. More recently, though, we rely on therapists. We have therapists on our staff, and we have several who volunteer with us who work with a client over a period of months, sometimes years, to continue to fill that gap that we're trying to fill. The people who actually need more support in understanding themselves and doing the work, this introspective work that we've been talking about, because it's not available in the prisons. But the prisons do have to accommodate those outside therapists. The other thing I'll add, something that really makes a big difference for us in our work, is because we're attorneys in this kind of unusual context. We have a lot of people as part of our legal team who get to come in on legal visits, or nowadays having legal phone calls as part of our team, because this is what this legal work requires. And so whether it's a therapist or it's a student, either a therapy student or a law student, they get to come in under cover of our being a part of our legal team. It's the only way we could be effective, and frankly, the only way many folks inside would have access to those kind of resources.
Well, so it sounds like a student intern at your place could really do some very meaningful work.
Indeed, they do, and they have.
Well, that's good. Let me ask you about something else. Besides, you were mentioning, I think you said 258 people had gotten out, I think, if I heard you correct, as a result of your work at a given moment, like right now. How many people is your organization representing?
Well, we do a lot of different things. I mean, it's, okay. I guess traditional representation, meaning we're going to represent them in their upcoming parole hearing. I want to say this year, there would probably be around 50 people that our office works with. In addition to that, we have several people, actually it ends up being a couple of dozen people, for whom we conduct what we call a consultation, which means we will look at their prior parole hearing transcripts. We'll look at a psychological evaluation, other documents in their files, and write a fairly extensive letter that guides them in first understanding what went wrong at their last hearing and how they can address it going forward, including providing resources that they need that just don't exist in the prison. That's actually something that a lot of students do. I also teach a class at Berkeley Law, and those students do these consultations all the time. And a lot of our staff do the same thing. We also have a couple other programs through which we try to serve groups of people at a time. We just launched a program inside a prison where we'll serve another 60 to 90 people this year, in addition to the numbers I was just talking about. So we're trying to expand our reach as much as possible, and we want to make it so that someone's release from prison is not dependent on having an attorney advocate like us, that we want to make sure there are more resources available to them in prison. At the same time, we want to make it so that I want to say it this way, the discretionary parole process is less subjective, that there are more objective factors that people can actually work toward and be measured against in order to determine whether they could be released.
Right. Could you talk also a little bit about what you do post-release with people?
A lot of our work, the overwhelming, majority of it is before we ever walk into the parole hearing. And what that looks like is, among other things, it is laying out what someone's plans will look like if we're successful in the hearing. So we will have already lined up a place for them to live, often employment opportunities, either a firm offer of employment or at least an offer for interviews. We'll already have that in writing before the person goes to the parole board. And the place to live, usually at least one option, will be a transitional housing option. And so that may look like 6 months to a year in a supportive transitional sort of halfway house, usually with other people recently released, but also with services to help people plug in a meaningful way, which may mean helping them with license, driver's license, other identifications, Social Security cards, those kind of things. Sometimes there's, job training programs there. And perhaps most importantly, there's often a continuation of some of the kind of therapeutic programming they had when they were inside. But I will say, to the extent that kind of continuation exists, it's largely driven by and facilitated by other people who are formerly incarcerated. People who come home recognize what those who come home need, and they provide it because they're committed to supporting each other, and they continue what they started when they were in prison. So we don't actively provide that support, but we make sure it's in place before the person is released.
Understood. I think everything in the criminal justice, or should I say the criminal law system, involves race. So I would like you to talk a little bit about how you see race playing a role in parole issues.
Well, I'll say that just like every other aspect of the criminal legal system, Black and brown folks are overrepresented. Among people serving life sentences, about 70% are Black and brown. And that's true in California, and that's true across the country. California has by far the largest population of people serving life sentences, but that particular racial breakdown continues. And there was a study a couple of years ago, I guess, it's about 2 years ago now, in which there was a review of a couple of hundred parole decisions. And they were focused on, there was a new law that passed that allowed for special parole hearings for people who were convicted and sentenced when they were under age 18. You can get a life sentence in California as young as 14, it used to be. And so this researcher, her name is Kristen Bell, she looked at the first couple hundred hearings that were held under this new law that were supposed to give special consideration to people who were young and whose brains hadn't developed, et cetera. And she found that people who were Black and who were poor were more likely to be denied parole when controlling for everything else. And with that data, it was like, wow, okay, we should do something about that. We should know more about that. And in fact, again, that was a limited study of just a couple hundred hearings. She then sought, in partnership with researchers at Stanford, additional data on thousands of hearings and regular adult parole hearing cases. And the parole board fought them. They said, no, we don't want to give you race data. We shouldn't do that. Here are all the reasons we shouldn't do that. So they had to fight them for 2 years to get the race data. For whatever reason, the parole board and the Department of Corrections didn't want to look at this issue, which makes you believe that there must be an issue there. And so they've only recently gotten the data. We expect to see maybe some similar results once this race data is analyzed. But there's zero reason to expect that we would find any different patterns in this larger group. So it's really going to require some changes in the way parole board operates. And the one thing I'll add about that is, with California's new Racial Justice Act, there may be some pathway to really take a close look at the role of race in parole decisions and really improve the system. It's something that hasn't been explored yet. I mean, the law's just taken effect. We don't know the full scope of it yet, but if it doesn't yet get to the parole board, it should, is what I'll say. I saw there was a question about what I meant by poor. I mentioned that there's a statutory right to counsel in parole hearings. The parole board will appoint someone. They have a panel of, I don't know how many attorneys are on this panel now, that they'll appoint to represent someone in the parole hearing. So poor means people who are appearing for their hearings with a state appointed attorney because they could not afford to hire their own. And those attorneys have a much lower rate of success in their hearings than privately retained attorneys. On average, I think they're around it's under 20%. It's somewhere around 18%, something like that of success rate. Our attorneys are around 60%, for example, by contrast. So it's not really close. And this particular research, her paper is called "A Stone of Hope." Worth taking a look at.
Right. Do you think is besides the individual representation, your report of that study by Kristen Bell, is that something that could give rise to some litigation dealing with the entire system? And is there any other systemic litigation going on at the moment?
There is some in the works. There's not a lot I can talk about right now.
Okay.
I'll say there's not enough though. Frankly, there's so many aspects of this process that are completely arbitrary and so clearly violating people's rights to basic due process. But frankly, when I started Uncommon Law in 2006, it was because it seemed like there wasn't really an advocate for this population of folks. Right. And in some ways that continues to be true. There aren't enough advocates. And I mentioned the 35,000 of people serving life sentences. The reforms that have been put in place over the last few years are rarely automatically releasing people from prison. Instead, they are often funneling more people through the parole board so that in addition to the 35,000 people serving life sentences with the possibility of parole, you have thousands of additional people who either because of their age at the time of the crime or their age now, their physical condition, some other things, now they're being considered for parole. So that the parole board is hearing more than half of the people who are currently in state prison. And they all are going through the same very difficult process I've just been describing. There's plenty of room for additional litigation, additional research. I'd be happy to talk with you or any of the students about what may be possible in that arena.
Well, that's very encouraging, and we're getting near the end. So I was just going to ask you again, just to clarify. So if people go on Uncommon Law's website, they can find where there would be the process for applying if you wanted to get an internship.
Yes, that's right.
Okay, that's good. Right. And are there any little closing remarks you'd like to make? Anything that we didn't ask you about?
I guess I would just say I would encourage people to consider, as you look at a job or you're in a job or even in an internship, really consider whether it fits you or whether it's whether kind of traditional lawyering is your thing. It wasn't mine. I didn't know there was an alternative. I never met anybody who does what I do until I started doing it, which can make things kind of lonely. There are a few people who I could reach out to and who guided a lot of my efforts, but very few none who had started a nonprofit focused on this area. But once I got into it, once I committed to it, I said, yeah, this is what I'm supposed to do. This is the right fit for me. So I would just encourage people to look for that thing. And it may not exist anywhere. You may not see it out there, but you may have to look inward and just be honest with what feels right for you and go with that. It may be something uncommon.
Maybe something uncommon. Well, thank you very much for your time. Very illuminating and inspirational talk. And we'll be posting your talk on our website, and I will be encouraging students to check out yours. Thank you very much, and good luck with your endeavors.
Thank you. Thanks for having me, and good luck to all the students.
Thank you. Thank you very much.